to stay active and help the pain. I think because of the sitting, she's concerned and she requests to be disqualified. Prosecution, 53.
Yes, I wonder what she would say if she's reminded.
I'll ask her. Okay. Juror 41. And I recall this woman because there's something else I wanted to put on here. This was the woman whose son is in DOC, and she described that it caused her some degree of anxiety when she came into the courtroom. And she says she cannot do this day after day. She says court is an unpleasant experience. She says she's not been sleeping or eating since she was here for jury selection on March 22, and she feels that if she's in trial, she will have a breakdown. I have to admit that when we got to the end of that day and she saw that she was coming back, I remember her being in tears on that day. So I am inclined to release her. Prosecution. Mr. Tellini?
I'll defer to the court.
Okay, I am going to release her. Juror number 63 spoke with her employer, and she does get paid for jury service, but only for limited jury service. She does not get paid after 5 days. She says then it's unpaid, and she believes that she would be unable to go without pay for that length of time of trial. So I will release juror 63 as well.
Question on 63.
I'm sorry. It is a male. I'm sorry.
Just want to make sure.
You're right. No, you're right. You're right. No, I misspoke. I am releasing 63. Yeah, he contacted his employer. I think this was the guy that said, yeah, I think I get paid, and then he found out that he doesn't get paid for as long as what he thought. Juror 44. Oh, this was the guy that called about because he has a large truck, and I think we've got that figured out. So I will follow up with some of these others. Well, he identified himself by name, which is how, let's see, 2702, let me make sure. Oh, we have, this is, yeah, he's not in seat. Yeah, except that, oh, got it. Yeah, right. Wrong chart. Okay, he is in seat, whoops. He is, where'd he go? I have 2702 as juror. Oh, there he is. He's in seat 17 on the 11 o'clock chart. So, and I think we got that worked out. Okay, so for sure I'm in the right place here.
Go through the again.
Working on it. Give me a minute. Give me a minute. Here. See, 277. Seven. Okay. So here's what I did. The person who is currently sitting in seat number 6, that is the person that knows Detective or Sergeant Soros. Where is it? Detective Soros. That person is excused. The person sitting in seat 9 is excused. I will follow up with person in seat 18 regarding court care. Person in seat 23 is the one that was asking the DA, or that had a comment about the DA questioning on beyond a reasonable doubt, and feels that his credibility has been impacted and it's on his mind. I will do a follow-up question with him. Juror 28 is being excused as a result of work issues. Juror 29, you can follow up if you want to. That's the person that said they've got it worked out with their employer. I will also follow up with juror in seat 32 that has sciatica issues, and see if standing and all of that will help her. Or no, that's not that. I'm sorry. Yeah, that's not the sciatica. Sciatica is the next one. This is the one that has the work issues as the teacher. And that is, she is in seat 32 currently. The next one, 1605. Juror 53 is the one with the sciatica issues. I'll follow up with her. Juror 41 is being excused. And juror 63 is also being excused. So people that I have being excused, excuse me, are jurors 6, 9, 28, 41, 63, with follow-up to jurors 23, 32, and 53. Does that answer your question, Mr. Young?
Yes, sure, thank you.
Okay. Anything from the defense?
Was on 18, were you gonna, was that a follow-up on the course care?
Yes. Yes. The only
Engineer.
that is seat number 23, and I will follow up with him to see what he's talking. He says this issue is on his mind and it may be impacting his health. I don't know what he means by that. So that's where we are. Go ahead and bring him in. Oh, okay.
Just so that we understand how this is going to work.
Sure.
Are we going to designate which seats are alternate? And how are they going to fill in gaps that end up on this box?
Okay, wherever, the best way to think about this is once we have our 50 that you can start exercising peremptories on. And I don't know whether that's going to be this morning or this afternoon. But it's fair that you be able to look at everybody so you know who the pool is. So we got the pool, and everybody that is there, and none of those people are going to be excused. So what will happen then is you can exercise your peremptories anywhere in the room. And the best way to describe it in this case, the highest seat number jurors, the last 6 are going to be your alternates. That makes sense?
13 through 18.
Yeah, step up here and I'll show you. It's a little bit easier to show you. Okay. So let's assume everybody is here. Let's assume everybody's here, including the strikes, because I'm not going to send really anybody out. Well, no, say I excuse these people. So I excuse these 4. So these seats are vacant, right? So by default, all these people slide down. So this person then takes this chair if they're selected. So you can use your 16 anywhere that you want. And then let's assume that these are your last 6 jurors chosen along here. Those are going to be your alternates, with this being alternate 1, 2, 3, 4, 5, and 6.
Assuming they end up down here.
Correct.
Assuming last what's in the box.
Assuming that they end up in the box, right?
Yeah.
Does that?
And then they're just going to snake in. So this will person will
Right.
go here.
Everybody's going to slide down.
Yeah, we'll come up.
Okay.
Yep. Does that? Anybody have any questions? Does that
No.
make sense to everybody?
Yep.
Makes
Okay.
sense.
Okay. Not that that record's going to help a bit, but we had it and they had the diagram. So there we are. Okay. Is there anything else that we need to take up from the prosecution?
I'm sorry, Judge.
Anything else we need to take up?
I don't know if we want to do this now or when we get, before we do opening, but we intend to dismiss count 3, which is abuse count. And so for, we charge this case
Right.
with child abuse. Knowing first degree child under 12 was originally count 1. Child abuse resulting in death was count 2. That was done before Gannon's remains were found. Once Gannon's remains were found and we got more evidence on the scene, one. And then count 3 doesn't really fit. So we'll be dismissing count 3 going forward on counts 1 and 2.
Let's do that before openings. That would make more sense. Yeah. No, I appreciate that. Anything else from the prosecution? From the defense, Mr. Tellini or Mr. Cook?
I'll do it before. I do have a motion regarding I'm maintaining my position regarding the changes. I can either do it now or.
Let's wait until after. We'll do it just before opening statements. That work? Okay. All right. All right. Let's go ahead and bring him in. No, but it seems to be working, and that's all that's all that counts.
Instead of the benches.
This afternoon. Oh, okay. They're not switching out anymore. That's what's Q. Yeah, because we still got that one. This row. Third grade seating chart, not as easy as everybody thinks. At this moment, council approach, please. Council approach again, please. You said 60, 60. So 46, 60. Good to go back. Okay. Court will call. All right. Court will call 20 CR 1358. People versus Letecia Stauch. Record should reflect the jury has returned to the courtroom. Good morning, ladies and gentlemen.
Good morning.
That was so much better than the last time you guys were here. We're gonna start out again, and I'm gonna have all of you stand and raise your right hand, please. Do you and each of you solemnly swear or affirm under penalty of law to answer truthfully the questions asked by the court or counsel concerning your service as a juror in this case?
I do.
Thank you. Go ahead and have a seat. I wanted to follow up because some of you have contacted this division, and I want to follow up and make sure that I have the right jurors and the right issues, and then see if there are any others that I may have missed. And I know that it's going to be a little bit confusing to all of you because the last time that you were here, you were probably sitting in different seats. And so we're all doing our best, and we'll try and get through it. So juror number 6 over here. Yes, juror number 6. I just wanted to make sure. You had said that you were or you knew Detective Siroy. Okay. And you were also close friends and know his kids well. Oh, okay. Okay. All right. And then juror number 9, second from the end. You were the one that was working the 12-hour shifts Thursday through the weekend. Do I have that right? Right. Okay. Um, Juror 18 in the front. You had called to ask about court care. Did you get that all resolved? Okay, just wanted to follow up. And then juror, this is the right one. Just a minute here. Juror 23, I think in the back. Did you, for on the end there, ma'am? Yes, that would be you. Juror 23, did you contact the court? Oh, whoops. Yep, you're right. Juror 23. I knew that. There we go. All right. Juror 23. Um, you had contacted the court and said that you had some concerns. Um, you said that after the questioning in the court that there was something that was on your mind, and you said that it might be impacting your health. Can you tell us a little bit about that? Okay. Do you do you think that that was as a result of being here and some of the stress that you were under here? Okay. Juror 28 on the end here in the front. Um, you said that you had contacted your employer and are not, uh, there's no way that you can do a 6 to 8 week trial because you won't receive a paycheck. You contacted your employer. Okay. All right. And juror 29, you had also contacted the court and said that you've got it worked out with your employer? Won't be that way. The way an alternate works is that you're here the whole time. Okay, yeah. No, so yeah, I think we have your concern addressed. Juror 32, you had contacted us and said that you're the teacher, right? Okay. And help me understand this, because the message that I got is that you only get paid for the whole week if you're working there Thursday? What is that? Okay. S- So we're good? We're okay. All right. Okay. Okay. That's okay. That's what I wanted to follow up with. Um, okay. And juror 16. Yes. Did you have a doctor's note for me? Okay. If you would hand that to Mr. Combs, please, and I'll get to that in just a moment. Thank you. Okay. And juror 53, back row, you called and said that you had some sciatica issues. Does it help if you can get up and stand? And you're also going to be, it's not a whole lot better, don't get me wrong, but the chairs are a little bit better than what you're sitting in. Okay. Okay. And juror 41, you had contacted the court as well? Striped shirt. Yes, ma'am. Yes. You had contacted the court and said that being here in the courthouse was causing you some stress. How are you doing? Well, I remember when you got the card that had your report back. I remember that you were a little teary when you got that. So it was, and it sounds like it's not gotten better. Okay. And juror 63, let's see, something's not right here. I think you guys reversed those. Something's not right here. Okay, now this makes a little bit more sense. And juror 63, there we are. Yep, nope. Face matches the name, works great. Okay. Juror 63, you had said that originally you thought that you were paid for jury service, and it turns out that you are, just not as long as what you thought. Okay. All right, just wanted to make sure. Okay. When you all were last here, You were all qualified to sit on this jury. However, I know that circumstances may have changed. I've spoken with some jurors. Is there anyone else whose circumstances changed that I've not spoken with? Whoops. All right, juror number 4. What's the circumstance that's changed?
I'm currently having an issue with DFAS. Categorize me as AWOL.
Okay, so what is the issue?
So they categorize me as absent without leave, and so I'm not getting paid, and I have to go to the finance department that's only open Monday, Tuesday, Wednesday, and Friday to get it fixed, and I have to sit there and talk to them. I have to go talk with the JAG officers, explaining I never left, I'm still at my station of duty, and stuff like that.
Okay, we've had other military people. I think we may still have some military people on here. What is different about your circumstance?
So DFAS controls pay.
Okay.
And I'm not getting paid because they put a blockade on it, and I have to go to them to get it fixed so I can start getting my pretty much my payback, all my
And
pretty much the military's put a hold on my account,
okay.
and I have to fix it first before I can do anything, because if I don't fix it, it'll start a cascade of problems.
Okay. And is a letter from me going to help that?
Maybe. I have honestly no idea, sir. We're currently right now, the issue is I had a deletion of orders to go overseas, and currently finances still have it in their system that I was supposed to go there. And right now the fight is saying I got them canceled.
Oh, so that doesn't have to do with this case, though. That occurred sometime before, right?
Yes, sir, but still, as of right now, I have not been paid by the military, and I got
Okay.
that thing.
Okay, I think I understand. Anyone else in this group? Juror number 15?
I've had a dental emergency over the weekend. That's what this is. It's going to require a root canal. I haven't scheduled that. Or it's okay. But I don't know.
So if it happened over the weekend, it sounds like maybe you haven't spoken with the dentist yet?
No, I went in to see him on Friday,
Okay.
and he gave me antibiotics just to stop the progression,
Okay.
schedule a root canal.
Okay. Okay, let me think about that one. Anyone else in this front row? On the end, juror 10?
It's fine having met.
Anyone else in this group here? Anyone else in this group? Juror 24?
Surgery.
Okay. I think we'll be done by May 25. Okay, anyone else in this group over here? Juror 39? Juror 39? Yes. But it's not scheduled? Okay. Anyone else in this group over here? Juror 40. Yes. What kind of work is it?
I designed for it.
Anyone else in this group over here? Looks like Juror 49. Yes, sir.
Yes, I did not let you guys know at the beginning that I'm a single homeowner. Only pays me 3 days of, with me being a single homeowner, it'd be kind of hard for me to, I don't know how the court system pays.
Right. Right. Anyone else back here? Juror 54. Over here. Juror 30. As I said, Monday, Tuesday, Wednesday, Friday, 6 weeks.
Radiant enormous opinion.
I've already spoken with you. You're 45, I believe it is. Yes. I was going to ask about that.
I also talked to my boss, and I'm a practitioner. Only two of us, right? Cover for me. I would be able to.
I just want to make sure I understand this right. Your pregnancy may be an issue for service here, but you're going to still serve as a kickboxing instructor?
Yeah, I mean, I can teach without actually having to do it.
Okay. Just making sure I'm following the whole progress here. Okay. And in the third row there, juror 61. Yes, ma'am.
My husband scheduled several appointments. Put off 6 weeks. I myself have come down with the fact.
Else in this back group? Back. Juror 74. Yes. Okay. And juror 75, you sort of went like this. Wasn't sure if you were actually raising your hand, not raising your hand. What's going on? All right, the last time that we were here, we had also talked about the publicity this case has received. Those of you who are here all said that you could put the publicity and other people's opinions aside and decide this case based only on the evidence presented in the courtroom. We also talked about the need to guard against exposure to publicity and anyone's opinions regarding this case from the time you were last here to now. Is there anyone who believes that they have been exposed to any opinions or stories since we were last together, and you don't think you could put those opinions and stories aside and decide this case based on the evidence you hear in the courtroom? Please raise your hand. Response? Do some checking here. Give me just a moment. Is there anyone that I've not spoken to who believes that they could not serve on this jury for the period of time, or either because it involves the circumstance that it does? No response. The people who have returned to this courtroom were all selected to return in this case because you all agreed that you could decide this case in a fair and impartial manner. Has anything occurred since we were last together that causes any of you to believe you could not continue to serve in a fair and impartial manner? Please raise your hand. No response. All right. Council approach, please. Okay. So I'm going to, if I excuse you, stay in your seat until we get to the end. And then all you can wait at one point in time. But you're number 4, 6, 9, 15, 16, where I call your excuse with the court.
I'm so sorry. I was trying to take a lower chair because my feet are hanging.
Not just yet.
Well, she just
Oh,
changing
Not
chairs.
just yet.
Just the chair, not the position.
Oh, that, oh,
I'm sorry.
you be in the same position? Yeah, that's fine.
It's
No,
okay.
no.
Thank you,
Sorry.
Your Honor.
It's all good. Oh, I see. Yeah, I see what you're doing. Yeah, no, that's fine. Perfectly fine.
Thank you so much, Your Honor.
Okay, no, it's all good. Yeah, so. All right. Is there anything, um, is there any reason why anybody believes that they could not serve as a fair and impartial juror in this case, if selected to serve? Please raise your hand. If you are in this room, you should anticipate that you will be on this jury. So if there is any reason that any of you have, that causes you to think why you could not serve on this jury, please raise your hand. No response. All right, counsel approach, please. All right, ladies and gentlemen, what we're going to do at this point, oh, sorry, Beck. Ladies and gentlemen, what we're going to do at this point in time is we are going to select the jury in this case. The jury is actually selected by a process of deselection, and we've spoken about that before. What that means is that you will see the attorneys handing a sheet back and forth between themselves. And when we get done, I will read the numbers of the jurors who will, or the numbers of the people who will serve as jurors in this case. Yeah, okay, let's check. 2, 3, 4, 6, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 22, 23, 26, 27, 29, 30, 31, 32, 35, 36, 37, 38, 32, 46, 47, 50, 50. And this does take a while. I think what we'll do is, well, actually, for this part, we do need to have everybody in the jury room, so, or in the courtroom. So it will take a little bit of time. You can feel free to stand, stretch, talk quietly amongst yourselves if you want to do that. That's right. I heard a voice somewhere. Oh, hold on, hold on. Juror 20, yes, ma'am. Have they been given any more information about you? Was that the question? Not for me. No, anybody is, it's not uncommon that one side or the other or both will sometimes see what information they can find out about a potential juror, a potential judge even, and potential witnesses. But there's no other information that was given to anybody by us, by the courts. Maybe that's the best way to put it. Does that answer your question? Yes. Right. Right. Yeah. Those questionnaires that you filled out, Right. No, remember the comments that I made was that the court staff, the attorneys, and their staff will know who you are, but nobody else does. Because constitutionally, they're entitled to know that information. No one else is. Does that answer your question? Okay. I'll double check, but they should be. council, while I'm doing this, I want you two to compare with each other. Compare with each other, and we'll do the same once I get it marked out. Council approach, please. Stack these 9 and 9 instead of. Makes a little more sense that way. All right, what I'm going to do now is, much like we did on the other days, I'm going to tell you to stay in the courtroom and who is released. But everybody wait in your seats. I'm done because I have the attorneys confirm that this is, in fact, the jury pool. So juror number 1, you'll be staying. Juror number 2, juror number 3, 7. 13 or 14. Right. So those people whose numbers I have called, stay in your seats. Everyone else is released with the thanks of the court.
Good luck.
So let's do this. Juror number 7, if you move down here next to juror number 3, then juror number, actually, let's do it this way. You'll take that seat right there. 13, if you take the seat in between. Juror 13.
Hello, hello, testing. Can everybody hear me? I know you can't see me, but can you hear me? We are finishing up final jury selection. We will have video available when opening statements begin. Justice for Gannon. Thank you guys for joining us today. Hey, Brenda. Thank you so much for joining us. I have been out running errands. My daughter has been keeping up with the stream. She did a great job. We have sound that's in and out. This is the webinar that we are connected to. So you will hear Judge Werner pop in and out here as he's doing the final selection. I am excited, guys. We're just waiting on it, Amanda. So as soon as he's selecting the jury now, he's telling who's staying and who's going. And I think as soon as he gets finished with that, he'll probably do a break, like a 15-minute break would be my assumption. And then we will get started with opening statements. So make sure you guys are comfortable. Grab you something to eat.
Here's what we're going to do. We're going to take about
I'm going to mute, guys.
15-minute recess. What's going to happen is that Mr. Combs and Mr. Sproul will show you where it is that you meet, because now things change. What will happen is you'll come into the courthouse. Mr. Combs will meet you at a place. He'll talk to you about that, about how to get into the courthouse. He'll bring you in, and you'll come down the back hallway instead of the front hallway. And there's 2 rooms back here that we have for you, actually. So they'll go through that process. He'll explain how to get back there, what it is that you need to do to contact him. We also will have some juror buttons for you. We will have sort of a tablet that has some notebook paper and some pens and things like that. And if I can, before we go much further, if I can have everyone stand and raise their right hand, please. Do you solemnly swear or affirm under penalty of law that you and each of you will well and truly try the matter at issue between the people of the state of Colorado and Letecia Stauch, the defendant, and render a true verdict according to the evidence?
Yes.
Go ahead and have a seat. Now that you've been selected as jurors, there are some rules that you must follow. These are the same rules that jurors have always had to follow in every case. During the trial, this courtroom is a place partially isolated from the outside world. Your decision must be made inside this place, and you must follow its rules. You must decide this case based only on the evidence and the law presented in the courtroom. You must avoid any other information about the case from any other source. These rules are designed to make sure that this is a fair trial. There are 2 basic rules. First of all, you must not communicate with others or among yourselves about the trial as it is going on. You cannot discuss the case while it is pending. You can talk about all kinds of things back there, just not the case. And I know it's a natural reaction that, what did you think about that witness's testimony as soon as you get back there? You simply cannot do that. In addition, you must not do any independent investigation or research about this case. I want to go over these rules in some detail because they are very important. In addition, if I learn that any of these rules have been violated, it may be that we have to start trial all over again on a new date in front of a new panel, and we have to go through the whole process again. So these rules are very, very important. Please follow them. You must not discuss this case among yourselves in any way during the course of the trial. You may not discuss the case among yourselves until after you have heard all of the evidence and you begin to deliberate on a verdict. That's when all the evidence is done. I've given you the instructions and you've heard the closing arguments. In fairness, you must keep an open mind throughout the trial, and you should reach your decision only during your deliberations at the end of the trial. Do not permit anyone else to discuss this case with you or near you. If anyone, including one of your fellow jurors, attempts to do so, please report that fact to Mr. Sproul or Mr. Combs immediately. You are permitted, however, to explain to family, friends, and employers that you are on a jury, and you can inform them of how long the trial will last. You cannot say anything else about any aspect of your experience until you are released from jury service. Do not communicate with anyone else in any way, including in person, by telephone, cell phone, computer, the internet, or any internet service. This means you must not email, text, instant message, tweet, blog, or post information about this case or about your experience as a juror in this case on any website, listserv, chat room, blog, or website. That's really important. We had a case not too long ago where they were actually, I think they were in deliberations, and one of the jurors was starting to blog about their experience. And a mistrial had to be declared, and they had to reset the trial and start all over. Once this case is done, you can talk to anybody you want. You can tell them as much or as little as you like about the process, but while it's going, you can't. You must not read, review, or accept any communications in any form from anyone regarding this case or cases like this. This applies whether you are here, at home, or anyone else. Do not read about this case in the newspapers or on the internet, or listen to any radio or television broadcasts about the trial. The law even prohibits you from consulting a dictionary to clarify terms that may be used in this case. Why do we have such a long instruction on this? Because in my experience, I think jurors are trying to be conscientious. I think jurors sometimes go home and they say, gee, I didn't really understand that. They try and look something up so that they can have a better understanding about what's going on in the courtroom. You can't do that. Here's why. First of all, before any evidence can be presented in the courtroom, it must be allowed pursuant to the rules of evidence. This book. It's in this book. The Rules of Evidence governs evidence that's admissible in any trial, whether it's civil, criminal, otherwise. And those rules are in place to make sure that the evidence that you're looking at is reliable and it's admissible. And you may be looking at something on the internet, on the news, or whatever, and I can fairly guarantee you that that does not meet the rules of evidence for admissible evidence in a courtroom. In addition, before you receive evidence in this case, as I said, remember, nothing that the attorneys say ever is evidence. Evidence comes from somebody who comes up here, swears to tell the truth. You won't see the attorneys do that. You won't see anybody on the news do that. You won't see anybody on the internet do that. So they come in, first of all, they swear to tell the truth. Secondly, they're subject to questioning and cross-examination by both sides. And that's, it's referred to sometimes as the crucible of cross-examination to make sure that the information that you get is truthful or is accurate. And if you're looking up things or you're talking with somebody else, neither one of those are going to apply. So make sure that you don't do that. In addition, if you were to do that, I've told you that you can't discuss this case among yourselves. You can't discuss it with anyone else. If you had done that, no one would know that you had done it. And it's possible that you may be making a decision in this case based on information that neither side knows about. And that's just not fair. We don't decide things on secret information in a courtroom of law. Breaking any of these rules would violate your oath and could require a new trial before a new jury. Your misconduct would have wasted all the time that you, your fellow jurors, the court, the attorneys, and everybody have spent in putting this jury panel together and putting this trial together. So please, please, please do not do those things. Again, after trial is over and you have been discharged as jurors, you're free to discuss anything that you want to with anybody that you want to. You just can't do it while we are in trial. So what we're going to do is take about a 15-minute recess. When we come back, I'll have some further instructions for you and tell you what you can expect this afternoon. With that, all rise for the jury, please. Thank you. You may be seated. Record should reflect the jury has left the courtroom. So the plan is when we come back, I'll go through the preliminaries of what the jury can expect this afternoon as far as opening statements, those sorts of things. And then opening statements at 1:30, an hour per side. I'm not going to require evidence. If you have some that you want to put on, if you're not ready to put on evidence until tomorrow, that's fine. I told you that you didn't have to do it today, but we're a little bit farther ahead than what I thought we would be. So
So the first witness that we intend to call, we've already told them.
it's a long day for them. I think it may be, a lot for them to process and getting back and forth and all of that stuff. So that's fine. If we end up at, let's see, 3:30 or so, I'll let them go home. And then we will start up with evidence tomorrow. During the lunch break, you need to do whatever it is that you need to do to make sure whatever it is that you want to do, video, audio, all of that stuff is all ready to go. Are you planning on using photos, anything like that in your opening statement? Have you told them what it is? Okay. They're, okay, all right, just want to make sure.
Because there will be 2 short
You're playing it from your laptop?
Yes.
Okay, yeah. Yeah, I'm not, that should be fine. I should be able to regulate it from up here. The issue will be, I don't think it's connected to the microphones. Hold on just a minute. We should be okay. Yeah, that'll be fine. Okay. And Mr. Tellini, you wanted to renew your motions? Or did you have anything else? Sure. Okay. All right. Then we'll take our break now. All right. You want to, you want her at the table or in the?
No, she can
Behind you.
find it in the gallery, but
Okay.
she may be coming in and out.
That's fine.
Anything maybe.
You will need to let security know who that is because everybody else, I've said everybody aside from staff and people that are associated with the case, once they leave, they don't get back in until we take a break. So just let them know who it is. All right, court will be in recess then. Say 11:20.
All right, guys, we got 15 minutes. Everyone grab something to eat, something to drink, get comfy. And let's get ready to get justice for Gannon. I'm going to get myself situated. And then if I have a few minutes before the judge starts and video shows up, then maybe I can recap the case and kind of go over it for you guys. Tap the screen on your way in. Blue hearts in the chat for Gannon. Thank you guys so much for being here. Go get your stuff and get comfy. Let's get started.
It's really challenging.
We're gonna work that side.
Okay, we're good.
So strapped you got. And then you push. Yeah. And the top spread out. You're a genius.
Tomorrow, yeah. No. Thank you, guys.
The ones.
Some point of it.
Okay, I have more. No, I have more. Did you spill coffee on that one?
Outsmarted myself. So I can't. It's just.
So it's easy enough to do. No, it's easy. It's easy enough to do. You don't sound a whole lot better.
Me?
Yeah.
Yeah, yeah, I'm.
Still bothering you, huh?
I feel okay though.
Yeah. No, I mean, it's just, you can hear it in your nose. So,
It's his fault that now I'm stuffed up today.
Right down the line.
there you go.
That's why I stay away over here. There's a lot of sick kids out there right now. And there is a vicious stomach bug. Yeah. I think you're more, when you still have kids in school, you're more
Yeah, that's true.
to what's going on.
All of our questionnaires.
Okay. Yeah. Just put them on Mr. Combs' desk.
Including all of our seating charts.
Okay. Thank you.
Video.
Pardon? You mean the screens?
No,
Oh, no, I might start it when they come back. Well, yeah, because there's not a way to, we're not set up for it right now. So I'll start the video after lunch. Yeah.
I just want to know when we're live streaming or not, so
That's fair.
I should know when to. Yeah, I'm not trying to picking my nose.
Anytime.
What?
Should I get all the time?
I mean, you know, sometimes.
It's all like a live over here. Hey,
Just trying to work a check.
You want me to work out the podium here?
More than happy to sit on some. Basically, where it's. Said I want to come.
Okay, sure.
First off, Your Honor, I am reaffirming my motion for a change.
Just a
I would, I this to be last.
5 minutes.
Yeah.
5 minutes.
Okay.
Yeah, okay. Go ahead.
I would tie this in with the last motion that I filed as a confirmation bias. There's already expressed a preconceived that my opinion, that is not a fair and impartial jury. I also cite the court to people, Botham, Colorado Supreme Court, 629, 589, Colorado Supreme Court, and a lot of similar issues that we have here where there is overwhelming media presence. Much like Botham, the vast majority of jurors here publicity had a that it indicated that it had influenced. They cite in that a case from the United States, for Florida, that's that 95 SC 7. Quote is, in a community where most veneer men will admit to qualifying prejudice, liability of other protestations may be drawn into question. Or is it more probable that they are part of a community deeply hostile to the accused? Or likely they may unwittingly have been influenced. And so I would rest on my motion.
Okay. Prosecution?
What we learned during jury selection is that while there was certainly a lot of media coverage for this case, jurors that were seated just through extensive examination by both parties and to that if they had seen people are able to this information on trust and respect what we do in the criminal justice system and know heard of media coverage in this case based on what happened. That we ended up seeing and sworn in, all understood those. Still two other motions out there.
Okay, hold on just a moment. All right. First of all, I've made a ruling regarding this before. I would reassert that ruling. But in addition, we've gone through, well, first of all, everybody wanted to have a questionnaire about what people knew about this case, and I thought that that was appropriate. It was something that we were going to have to deal with, whether we dealt with it in a questionnaire or whether we didn't. But the questionnaire was provided prior to the time that any of the jurors received instructions on the law and what it was that was required, the presumption of innocence, the beyond a reasonable doubt, the right to remain silent, those sorts of things, which is something that all the jurors were advised about during the voir dire sessions. In addition, the jury has been seated at this point in time, And one of the instructions that I gave them was they can't do their own research about any aspect of this case, and they can't rely on any media and those sorts of things. And I told them why. And that's because of the applicability of the rules of evidence, and that whatever they heard or whatever they listened to was not subject to the same things that evidence in a courtroom is, such as the witnesses are sworn to tell the truth or they take an oath to do so. They're also subject to cross-examination and examination by the attorneys, and any of the evidence that is going to be admissible must be admissible pursuant to the rules of evidence. So I tell them why they can't rely on it. I think that it goes against common sense to say that because someone has an opinion about something means that they have to be disqualified per se. In People versus Drake, 748 Pacific 2nd, 1237, Colorado, 1988, the court said that the test to be applied in determining whether a prospective juror should be dismissed for cause is whether the person would be able to set aside any preconceived notion and render an impartial verdict based on the evidence adduced at trial and instructions given by the court. And all of the jurors in this case have said that they can do that. They all seem to understand the court's instructions. In fact, when I was telling this jury panel why it is that they couldn't do research about anything and why they shouldn't listen to the media and those sorts of things, I got a number of nods of the head as to, indicating to me that seemed to make sense to them. So that the motion for change of venue is denied. In addition, it would be difficult for, essentially, I think it was Judge Schwartz that had the story about he moved a case to, I believe it was Durango, based on pretrial publicity. And then the Sunday before they were supposed to start jury selection, the local newspaper ran a story about everything that was in the case. Again, I think given the coverage that this has had, we need to keep in mind that we need to have some sort of venue to try it. I would note that this case is not really different than the Dylan Redwine case that was tried in, was it La Plata County? It was down in Pagosa Springs. The Holmes case that was tried in Aurora, and those sorts of cases. So the motion is denied. Are there any other motions we need to address?
Because I think, and I don't.
Oh, right. Defense? All right. And just so that the record is clear, Ms. Stauch, you wish to waive a jury and have this case tried to me? Okay. Let the record reflect that the defendant responded yes. Again, I think that the case law is clear that in some cases where a jury cannot be, where a fair and impartial jury cannot be seated, that the court has a constitutional obligation to make sure that the defendant has a fair and impartial jury. And if one cannot be seated, then the case should be tried to the court. Having said that, the law is also clear that absent that circumstance, the prosecution has a right to have this case tried to a jury. And I believe that I have put mechanisms in place to make sure that we have a fair and impartial jury. And as a result of that, I do not believe that it is necessary that I and I alone decide these issues. As a result of that, the motion to waive a jury is denied. Is there another motion? Okay, we good? Let's bring him in. And just so that you guys know, now use the front hallway. Use the front hallway when you're coming in. So it's just flipped from what we did before. And each side will have a reserved pew, I guess, behind them. Yeah, that bench behind you, that first bench is reserved for the defense. That first bench reserved for the prosecution.
There's only,
That's the DA's problem. And you can let them know that if there are issues that I need to address, I will address them. What? You would have to ask admin, but not as far as I know. Because we're doing it as a live webinar, not as far as I know. I frankly don't think there's any space. All rise for the jury, please. It's okay. All right, thank you. May all be seated. Again, good morning, ladies and gentlemen. I wanted to apologize because I forgot to tell you one of the most important things that you need to remember before you left the courtroom. And that was look to your left and make sure that the person that is to your left comes through that door before you do. If you do that, you're going to be fine. Otherwise, you're climbing over each other to get to your seats, and I apologize for that. It's a rule that I always say, and for whatever reason, I forgot this time, and sometimes I do, and I apologize for that. So you've all been given juror buttons, and you have notebooks with notepads on them. And here's a couple of things that I want to talk to you about. While you are in the courthouse, please wear your juror buttons. You don't need to wear them outside of the courthouse, but please wear them inside the courthouse. It does a couple of things. First of all, it lets everybody know that you are a juror. So you may see other jurors that are wandering around with other juror buttons as well. What that does is it tells people that you are a juror. So it means that if potentially you run into witnesses, attorneys, somebody who may know something about the case, they will stop talking when you are around. Don't take that personally. They're trying to avoid even an appearance of impropriety. Again, don't take that personally. Secondly, it identifies you as a Division 15 juror. The courthouse can be intimidating. It can be overwhelming. And the architects who designed it designed all the hallways to look almost identical. It's an unusual place. People are sometimes anxious when they get here, even jurors as well. And so sometimes they get off on the wrong floor. And we have had jurors in the past become misplaced. Having that button on explains that you are a Division 15 juror. It will help a staff person help you get to where you need to be. So please wear them in the courthouse, but you do not need to wear them outside the courthouse. Mr. Combs has told you how to get in the courthouse in the morning. When you get out of the court, or when you come back after lunch, you'll come back through the Tejon Street exit, just like you did when you first came here, and how you got in this morning. You'll use that same process. Just come up to the 4th floor. Did you show them the video phones?
No, Jack talked about it.
Okay, so before you go, they'll show you where the video phones are, but they're right outside the elevator. You'll need to call us and we can let you in. So, in addition, you've all been given juror pads. They have some information, parking information for you. That's typically the one that is the most important for the jurors. We will also have some parking passes for you towards the end of the day. Don't leave without getting one of those. Make sure that you get one. It will make your life easier. It also has contact information for the county in case it gets lost, but I don't anticipate that's going to happen. But in the event that you need the contact information, it's also there. Your packet also has a question form on it. In Colorado, we do not allow, or we used to not allow jurors to ask questions. There's been a number of reforms over the years, and one of the reforms is we do allow jurors to ask questions of witnesses now. It has to be in a very specific format. However, you do not get to stand up and do your very best Perry Mason imitation. Instead, what will happen is when the witness comes on, suppose the prosecution is calling the witness. The witness will take the witness stand. The prosecution will ask some questions. The defense will cross-examine, and then the prosecution will do something called redirect. After that, the lawyers are done. What I then do is I ask, do any of the jurors have any questions for this witness? If so, you raise your hand, you write your question down, you put it on the bar in front of you. I'll have somebody retrieve it. They come up here and you get to listen to that wonderful noise. And the attorneys and I will talk about your question. I have to apply the same rules of evidence and law to your questions as I would to a question asked by an attorney. If the rules of law and evidence don't allow your question to be asked, I can't ask it. I can tell you that over the years, I've asked probably better than 95% of the questions that are submitted. If I don't ask a question, it's not a reflection on the juror, and you should think nothing of it. In addition, you shouldn't guess or speculate as to what the answer to that question may be. In addition, you've been given notebook paper. You can take notes. The notes are purely and entirely for you and you alone. Once this case is done, those notes are immediately destroyed. Nobody reads them. We don't grade them for penmanship, accuracy, anything else like that. So whether you want to take notes or not, it's entirely up to you. I am going to read a couple of instructions that may help you going forward. One of the instructions is you may have to decide what testimony to believe. You should carefully consider all of the testimony given and the circumstances under which each witness has testified. Consider each witness's knowledge, motive, state of mind, demeanor, and manner while on the stand. Consider the witness's means of knowledge, ability to observe, and strength of memory. Consider also any relationship each witness may have to either side of the case, the manner in which each witness might be affected by the verdict, and the extent to which, if at all, each witness is either supported or contradicted by other evidence in the case. You should consider all facts and circumstances shown by the evidence which affects the credibility of the witness's testimony. You may believe all of the testimony of a witness, part of it, or none of it. In addition, evidence may be either direct or circumstantial. Circumstantial evidence is the proof of facts or circumstances from which the existence or non-existence of other facts may reasonably be inferred. All other evidence is direct evidence. The law makes no distinction between the effect of direct and circumstantial evidence. Suppose, for instance, that when my children were younger, they had baked some chocolate chip cookies, and I told them that they couldn't have any until I got home. So I get home, I find the lid off of the cookie jar, and I find half of the cookies gone. I could conclude from that evidence alone that it most likely was not my teenage son that got into them because there are still some left. So I think of the next most logical culprits, and I call the twins downstairs. Sam comes down looking like she always does. She has a nice clean face and a nice clean shirt. I ask her if she had any of the cookies. She says no, at which point Kate comes barreling around the corner, running into Sam, and she has some crumbs on her mouth and some chocolate on her shirt. I did not see Kate actually take the lid off of the cookie jar, reach in, and take out a cookie. But I can conclude from what I do see, that's exactly what she did. The law makes no distinction between the effects of direct and circumstantial evidence. When you come back this afternoon, what you can expect is that we will have sort of a short afternoon. And this is on me because for planning, I wasn't sure how long it was going to take to get through the jury process this morning, whether or not we would still be in it this afternoon. So I anticipated that potentially we might have gone into this afternoon. So I flexed that with the attorneys. I said they did not need to present any evidence this afternoon. Evidence will start tomorrow morning at 9 o'clock. But when we come back this afternoon, what will happen is the prosecution will start their opening statement, and I've limited each side to an hour. So the prosecution goes first, then the defense goes. Then we will take a break for the day. I'll send everybody home. I'll have some further instructions for you at that point in time. When you come back this afternoon, feel free to bring in some water, some pop, some coffee, anything like that that you would like to. If you want to drink something in the jury box, that's okay. Generally, I can't allow food in the jury box. If somebody is diabetic or has an issue with respect to that, let me know because there's a way that we can deal with that. So let us know if that's an issue. You can feel free to stand, stretch. Those seats I know are not the most comfortable. I get it. I sit in one that's similar to that a lot. So I understand that. In addition, don't think we have that juror, but in addition, for any of you who are vertically challenged, sometimes you'll find that the seats don't go down low enough. And if that's the case, we have something that you can rest your feet on so you're not feeling like a 5-year-old in a barber chair. And we got one. We got you taken care of. So we will get one of those, and that should help. The other thing is that feel free to bring in a jacket or something like that if you want to. It always feels warm in a courtroom to me, but that's essentially because I'm wearing a blanket all day long. But if you get cold or something like that, just feel free to bring in a jacket. Again, as you know, most of the eating joints are north on Tejon. There are a few south on Tejon. And your day going forward, your court days will look like this. We need you to be in the place you need to be to meet Mr. Combs in the morning, and he'll get you here so you're here at 9 o'clock. We will start at 9 o'clock. We'll have about a 15-minute recess or a little bit longer than that, somewhere between 10 and 10:30 every day. We'll take a break at noon. We'll come back at 1:15, 1:30, something like that. And we will go into the afternoon, and we will have about a 15 or 20-minute break somewhere between 3 and 3:30 in the afternoon. Then we will stop at 5 o'clock. When we stop, you will be free to return home. Again, you can go on about your business, do anything that you would normally do, except talk about this case or do anything with respect to this case. If you have questions or issues, contact Mr. Combs or Mr. Sproul. They will let me know. And I think that covers most everything that we need to cover. So if we can have everyone back in the jury rooms a little bit before 1:30 so that we can start on time, we should be able to do that. Sounds like it's a beautiful day outside. If you want to go for a walk, that's fine. And we'll see you back at 1:30. All rise for the jury, please. Thank you. You may all be seated. The record should reflect the jury has left the courtroom So we'll be back at 1:30. We'll start evidence tomorrow at 9 o'clock. And I think that's it. Anybody else? Anybody have anything else? Prosecution, defense? Okay. All right. Thank you. Court will be in recess.